Hey class, so you have made it to week 16 and to the last lecture of the semester. Thank you for sticking with me and for staying engaged in the course, even in these difficult and interesting times. Today we are going to discuss how to most effectively use the legal resources available to you within your organization. I'm going to talk about how to work with counsel at a government agency, but this holds true for other organizations as well, particularly nonprofits, but also for for-profits. So government attorneys are different than, clearly, for-profit attorneys. Corporate attorneys, law firm attorneys, they advocate for and represent the interests of a company, usually as those interests are determined by the board of directors and shareholders. Nonprofit attorneys do the same, but with an eye towards some type of public benefit rather than profit. By representing agencies and other governmental bodies, government attorneys advocate for and represent the interests of the public as a whole. At both the federal and state level, attorneys work throughout all three branches of government. Now, as a side note, there are also many non-practicing attorneys within the government, academia, and the corporate world. They hold a JD, they might use their legal knowledge as part of the job, but they don't represent the organization as an attorney and thus can't provide legal advice to the organization. Now, cabinet level departments, federal and state, but let's look at, say USDA or a state Department of Agriculture. A lot of times they've got their own in-house legal offices. So do many agencies within that cabinet level department. Additionally, agencies that have field offices, they'll often have smaller legal offices embedded in those field offices or a regional office. And the number of attorneys in any particular government legal office varies widely, often but not always based on the complexity of the work that the agency does. Now, one thing to note about that complexity is that most government attorneys have at least a few years of experience before joining the government. It's rare for the government to hire attorneys straight out of law school or with only a year or two of experience, and that's because government attorneys get hit with real responsibilities right away, and there's not much time to train and mentor new attorneys. So some legal offices have the authority to represent the government in court, in criminal and civil litigation. At the federal level, those offices include the U.S. Department of Justice, obviously. That is the federal government's legal office in Washington, D.C. It also has various U.S. attorneys' offices, which are staffed with DOJ criminal and civil litigators, but they're located throughout the country so that these folks can try cases in federal district courts. The federal and state governments each have an attorney general's office. That is the government's chief legal counsel. At the state level, the AG's office is typically headquartered in the state capital or in its largest city. So for instance, Annapolis is Maryland's capital, but our AG's office is located in Baltimore. As the chief legal officer for the government, the legal buck stops with the AG's office. So that office typically handles all litigation, criminal and civil, on behalf of the federal or state government. Sometimes, particularly at the state level, you'll get assistant attorney generals embedded within agencies. They're there to provide in-house legal support rather than to litigate. So they operate more like traditional in-house counsel, which we are going to discuss momentarily. But first, just to continue with the litigation theme, at the local level, criminal cases are prosecuted by the district attorney's office or the state attorney's office, and the local public defender's office may provide defense counsel. And then depending on the size of the municipality, it might have a town attorney's office or a city attorney's office, and that could be staffed by a single attorney or numerous attorneys. But regardless, that office then represents the local government in a variety of legal matters. There are also in-house attorneys at many government agencies, as well as in Congress and in the judicial branch. And some of these attorneys litigate in agency hearings, but primarily they do other types of legal work. Since this is an administrative law class, I'm going to focus on the administrative law side of the legal profession, where attorneys are generally embedded within an executive branch agency. So these offices within the executive branch agency, they go by a variety of names. The most common across all federal and state agencies is probably the Office of General Counsel, but you might see Office of Legal Affairs or simply in-house counsel among other names. State agencies that don't have their own in-house counsel, their own in-house legal department, they typically rely on the state attorney general's office for legal advice. Government agencies can also retain outside counsel, which means they can hire a law firm, but that is often a difficult and expensive process. It's difficult because agencies can't just hire a firm, they've got to go through the state procurement process, so, issuing a request for proposals, interviewing candidates, etc. It's an expensive process because lawyers aren't cheap. In the Washington, D.C. and the New York City regions, big law firm attorneys charge between $600 and $2,000 per hour. And that might seem like a ridiculous waste of taxpayer dollars, and sometimes it is, but sometimes you just need an expert. And paying for that expertise is going to save money in the long run. And remember that attorneys invest years of their lives and typically over $100,000 preparing for their careers, and then additional years in their careers honing skills in a particular field of law and also forming relationships across the legal profession. So those skills, experience, and relationships can make attorneys worth that price. However, like I said, because of the difficulty and cost of retaining outside counsel, agencies mostly use outside counsel for specialized fields of law, like patent law or employment law, or even government contracts law. So let's take a look at the types of work an agency Office of General Counsel might perform. Now keep in mind that what is on the lecture slide, this is just a partial list. There are other duties as assigned. So many agency attorneys advise leadership on legal options or the legal consequences of policy choices. We also advocate for the agency's goals and its mission or missions. While in-house attorneys don't litigate in court, they do sometimes assist the Attorney General's office with civil litigation, especially tort claims. So it's the in-house attorneys who tend to be the subject matter experts for the agency's legal needs. They get the inside view of the agency, and typically the Attorney General's office doesn't have that view or understand those legal needs, and so they need that in-house expertise in order to win a trial or have a case dismissed or what have you. In-house counsel also, we engage in factual investigations. So investigations can cover a wide range of work. That can be, a prosecutor accompanying law enforcement officers in a criminal investigation, to reviewing medical records in a tort case, to reviewing documents to determine, what order a series of events took place or whether an agency had knowledge of something on a certain date. Throughout my career, I have engaged in a number of factual investigations, and some of those were really active. I have gone inside of coke ovens at steel plants to watch the hydraulic cylinders function. I've put on protective gear to examine fuel cells in a nuclear reactor core, put on different type of protective gear to examine conditions in animal care rooms, crawled around server racks to verify equipment tags, stuff like that. But the majority of my factual investigations are document review and interviews. In-house counsel also do a lot of legal writing and other legal communicating. Mostly this is now done via email and meetings, but a lot of times those emails might be formatted more like a memo. There are other times when a real memo is required, especially if you're providing detailed legal analysis or documenting why an organizational decision was legally appropriate. In-house counsel also do a lot of transactional work. So let's take a look at what that means. Transactional legal work, is about bringing people together to achieve organizational objectives. So it involves researching, drafting, negotiating, and advising from a legal capacity. Transactional attorneys handle all of the many documents that help organizations function and meet their goals. So transactional work includes drafting and negotiating a lot of different types of legal agreements, from grants to study cancer, to leases of space in a food court, to purchase orders for laptops for personnel. Transactional work also focuses on ensuring compliance with relevant regulations, such as ensuring that human research participants are appropriately protected in the cancer study, to following state procurement requirements to buy those laptops. Transactional attorneys, we almost never see the inside of a courtroom, but we dole out legal analysis and advice many times per day, including advice on how the agency should implement and comply with applicable statutes, regulations, and government policies, as well as fulfill its contractual obligations, and that includes any agreements with labor unions. We also handle a variety of internal matters, including providing advice on proposed policies and procedures, serving on a variety of committees and task forces, basically whatever needs to happen to be able to guide and assist the agency's decision makers. We negotiate contracts, we provide trainings, we review we review legislation. Sometimes we do review litigation, judicial opinions when they apply to our agency or similarly situated agencies, and so on and so forth. We are also expected to constantly monitor the legal, political, and operational environment so that we can flag issues that we see coming down the pipe for our clients. And because we work with so many clients in different parts of an agency, the legal office often serves as an informal nexus of information, so we can help bridge the gap between organizational silos and connect people who might not be aware that they share some common interest. So as an example, here are some of the legal topics that my university legal office deals with. Any type of agency, Office of General Counsel, needs attorneys who can handle a breadth and depth of subject matter topics. Obviously, a lot of these topics are going to vary by the agency's mission, but some of them, like public ethics law or workers' compensation, are widely applicable to all agencies, as are constitutional matters. Additionally, every executive branch agency needs in-house counsel who understand administrative law and regulatory compliance. So agencies have attorneys who know government contracts law, since that supports purchasing of everything from research to fighter jets. They've got constitutional lawyers because government agencies are all bound by the U.S. Constitution and have to be particularly cognizant of First Amendment, Fourth Amendment, and sometimes Eighth Amendment rights. Because the public sector has a lot of employees, agency legal offices need to know employment law and applicable privacy laws, and understand how they apply to unionized personnel as well as non-union professional exempt personnel. Because agencies purchase and lease land, as well as lease out their own buildings and land, they need legal offices that have a real estate attorney. They also need attorneys who specialize in tort law, because all of that real property is fertile ground for trip and falls and other tort cases. So these are just some of the subject matter topics that agency attorneys provide advice and counsel on. There are many more. There's cybersecurity law, accessibility and ADA compliance, HIPAA, and then all kinds of specialized areas that are critical to agency operations that might be watertime law, maritime law, criminal law, environmental law, etc. Additionally, attorneys have to be concerned about our own ethical behavior. Lawyer jokes aside, we are held to a high standard of professional ethics, and we can lose our license to practice and thus our livelihoods if we don't comport to ethical behavior. So attorneys follow the rules of professional conduct. That addresses interactions between attorneys and our clients, as well as our non-clients. It addresses things like attorney-client privilege, being truthful in our statements to the courts and to others, and otherwise just maintaining the integrity of the legal profession. Now, clearly not all attorneys are as committed to legal ethics as they should be, but I like to think that most of us take our professional responsibilities seriously, and that would include our oath to the Constitution. Government attorneys are also concerned with public ethics laws that apply to our organization and its personnel, because we need to provide advice about compliance with those laws on a pretty regular basis. So for instance, I often advise my university's personnel on whether they can accept certain gifts or freebies from companies that do business with the university. So our state ethics law allows state employees to accept things like a conference registration or reimbursement of travel and lodging costs from companies that do business with the state, if and only if those state employees are going to be speaking at a convention or serving as a panelist. So it can be very challenging if you've got a relationship with a company. They want to just give you some freebies, but if you work for a government agency, you're constrained by state ethics law, and you don't even want that appearance of some type of inappropriate relationship or conflict of interest. So public ethics law, it is especially prevalent at the federal level, where the government wants to avoid the appearance of a revolving door where government officials leave federal service and then immediately land cushy positions in lobbying firms, or companies that they regulated when they were working in government service. So there is usually a cooling off period of at least a year before a federal official can take a job with the private sector. And when leaving government service, government personnel, especially those in management roles, are often required to meet with a government attorney to go over that applicable ethics law. So sometimes I am asked by law students in particular, what a day in the life of an attorney is like. And there just is no standard day in the life, I think, of really any attorney, but particularly a government attorney. It varies by agency. It also varies by subject matter within an agency. But overall, we are all very busy. Most government attorneys I know work 60 plus hours a week. We are often in understaffed and under-resourced offices. And this is another reason why the government tends to hire more experienced attorneys. We've got to be able to hit the ground running and provide advice efficiently, effectively, and without too much in the way of support staff. In addition to numerous active project matters that we have, we've got standing meetings and then emergencies like the COVID-19 pandemic. We also have to keep up on important developments that are related to our agencies and our fields of law. So that includes reading the news, reading relevant professional publications, as well as keeping up with statutory and regulatory changes and court opinions. Like many attorneys, I spend a tremendous amount of my time writing. I draft or revise contracts, policies, procedures, reports, memos, plus a huge number of emails every day. And I have tried to gear the assignments in this class towards something that you may need to write at your own agencies, or that you might see from your agency attorney. And again, I really want to stress the importance of clear, concise writing. Everyone's busy, and you are more likely to be heard if you can communicate quickly and understandably. So for instance, for reports and memos, I always write up a first draft where I just put all my thoughts and all of my analysis, all of my recommendations, I just put it all out there on the page. And then I spend a lot of time viciously slashing it down to the bare minimum that my client needs to understand the situation and make an informed decision. So if you write well, people are going to take notice. They are actually going to read what you have written, they'll comment on it, and they're going to view you as a knowledgeable resource moving forward. Now, I feel pretty lucky to be a government attorney, and specifically a university attorney. It does not pay nearly as well as working at a law firm, but it provides a varied and sometimes wildly interesting portfolio. So one of my all-time favorite projects was being embedded with the visual imaging team for NASA's Cassini mission to Saturn. So I got to, at one point, sit with the imaging team as they used their cameras to navigate the Cassini satellite through Saturn's rings. And I got to be there when they found water spewing into space from the moon Enceladus. I got to watch a client drive one of the Mars rovers. I've gotten to see a trapped atom with my bare eyes in a quantum physics lab that I support. I have pulled racks full of like 30 pounds or more of honey from beehives, stood at the core of nuclear reactors, gotten to negotiate with major sports leagues, cut some random deals for racehorses, visited NSA headquarters. There's just really a lot of stuff that you get to do as a government attorney that you wouldn't necessarily get to do in private practice. Since the COVID pandemic started, many university attorneys and other government attorneys have pivoted to supporting pandemic response, and that happens in a variety of ways. We also, because we are public universities, for instance, are state agencies, but all government agencies have to be cognizant of the U.S. Constitution, so you can't, just necessarily track your people's movements or monitor them in public, because that might require a warrant unless you are a public health agency. Now, I also do plenty of just sitting at my desk, researching, writing, and thinking. But for me, I think that working at a university really provides a depth and breadth of legal work that I haven't seen elsewhere, although I imagine that providing legal support to city administration is probably somewhat similar. And while it's a lot of work, I see being a public service attorney as really one of the most important things that I can do with my law degree. Supporting research, supporting our students' educations, that's really important to me, and so for me, it's worth more than the paycheck of private practice. Okay, let's talk about why you should work with your attorney. As the old saying goes, an ounce of prevention is worth a pound of the cure. So here's a rundown of why you should work with your attorney proactively, not reactively. As we have seen, administrative law in its various forms, it underpins all public sector activities. And the best way to understand the law applicable to your agency, and perhaps even your specific program within your agency, is to sit down with your attorney and talk about it. Your organization's legal office is there to support your work, and it's there to protect you as agency personnel and the organization and the mission from legal liability. So effective agency action requires coordination and communication. And you don't want to waste time and resources coming up to speed with your attorney when you're already in the midst of a crisis. So it is best to just spend some time proactively building a relationship with your attorneys before you need them. Cultivating an attorney-client relationship can be difficult, particularly if you work for a large organization, if your legal office is in the same building, etc. So I try to get out of the legal office and spend time with my clients, to create a level of comfort that you don't necessarily get via email. Now, of course, we're doing it via Zoom because of the pandemic. Now, cultivating a good relationship should be a two-way street. Your attorney should make an effort to get to know you. But that can be difficult, especially again in large organizations. Thinking about the university, we've got around 14,000 faculty and staff and over 40,000 students, some of whom also work as graduate research assistants. We've got 10 attorneys. So it's a lot easier for the people sort of out there on campus to know who I am than it is for me to know who they are. So if your legal office is not working to build a relationship with you as a client, it's probably just because they're super busy, in which case I recommend that you take the first step. Once we can socialize again, offer to meet your attorney for coffee or swing by his or her office to introduce yourself. In the meantime, you could just ask for a 10-minute meet and greet via Zoom. I like the 10-minute meet and greets because it lets me know that it's not going to take up, a whole 30 minutes or hour of my time. Consider working with your attorney whenever you're developing programs or procedures, or at least alerting your attorney to the project. So the point is that you want to be able to collaboratively detect, identify, and examine various problems that might occur, and your attorney is there to help you with that. If you aren't sure how to proceed and your attorney's not available, just follow up as soon as you possibly can. Document the reason why you didn't get legal review, but know that getting the legal office involved early will save time and resources later. So one way to work in unison and build a relationship with your attorney is to engage in training activities together. Invite your attorney to attend one of your staff meetings, provide the attorney with an overview of your unit's mission, the people within your unit, or ask your attorney to provide a quick training session about a topic of interest to your team. So I routinely make my way around our various schools and colleges to provide training on things like responsible conduct of research, public ethics law, intellectual property law, and so on. So you want to collaborate with your attorney and engage in mutual learning. Find the most effective way of elevating issues to the legal office and just make sure that everyone understands the process and is on the same page. I support several large divisions on campus, and in my opinion, anybody who works for one of those divisions is welcome to come to me directly, but some divisions want their people to go up the chain of command before contacting the legal office. Ask your legal office to help you identify larger issues and concepts and address them collaboratively. Involve your attorney, like I said, in planning major projects or developing policies so that you can avoid common legal problems. And most of all, spend some time learning from each other. Attorneys need to learn what format of legal advice is best for you as a client. Do you want an email with 3 bullet points, or do you want a 2-page memo with citations? Do you want a phone call as well as a written product, etc.? Clients need to learn about legal risks and how to mitigate them. And finally, remember that the other side is human. So invite your attorney to departmental meetings so that you can get to know each other. You and your legal office should work together like the interlocking gears of a fine watch. But that can only happen if you proactively maximize your relationship with the attorney or attorneys in your legal office. So again, understand that they're here to help the agency meet its goals and protect the agency, and they might have a more holistic view of the organization because they work on so many varied projects across the agency. I recommend that you try to get a feel for your legal department's risk tolerance. Historically, many government legal departments have been overly risk averse. They basically act as the office of no. Don't go to legal because they'll just say no. That is an unfortunate side effect of the desire to insulate an agency from legal liability. But fortunately, this approach is changing as agencies and their legal offices just have to become a little bit more flexible and nimble. So my office, for instance, does its best to find that path to yes for a client. And on the rare occasions that we say no, it's because there's a bright line law on it, or we've exhausted all potential options to say yes. So as a government attorney, I implore you to help us help you. Work with, not around, your legal department. Provide your attorney with complete and accurate information. Something that might not seem relevant to you could be important from a legal perspective. Keep your attorney updated. Provide any requested documents as quickly as possible, and then ask questions and let us know about deadlines. At the same time, just understand that your legal office is very busy. Legal input can take time, especially if your legal office has to work with another department, somebody external to your organization, or if they're on the critical path for a wide variety of business decisions at an agency, because that means that people from all across the agency are sending projects to the legal office. Use your in-house counsel, again, proactively, not reactively. It is easier for attorneys to help if we understand your operations and we know your concerns in advance. So that's why it's important to create these opportunities to work with legal counsel. You want them to understand your goals, priorities, methods, etc. Because if your attorney understands your mindset, she can act as your agent in unexpected situations or flag issues raised elsewhere for your review. This is where, the legal office can really act as this nexus to connect the right people across your organization. I recommend extending occasional invitations to your attorneys to attend important meetings. Let us, introduce ourselves, get everybody to put a face to a name. Also use limited time opportunities to engage. Elevator conversations, waiting in line for lunch, stuff like that. And don't forget social events. I play fantasy football with a bunch of my clients, and it's a really just great way to get to know them. And I think, honestly, getting to know them on that level helps me provide more effective legal support. So be friendly and engage with your attorney, and they will more than likely go out of their way to support your projects. You also need to understand attorney-client privilege and how to protect that privilege. You should talk to your attorney ahead of time to make sure that you know what types of communications are privileged. So first and foremost, for attorney-client privilege to apply, you've got to be a client. Attorneys, we represent the agency or the organization, but we do so through its personnel, so client can be fairly broadly construed for the purposes of attorney-client privilege within an organization. Many people within the university contact me directly for advice, and my conversations with each of those people, from procurement buyers to the provost, are privileged if I am providing legal advice about, the university's operations, and there's an intent to keep that conversation confidential. Here, confidential means restricted to people within the organization who have a need to know. If my first discussion is with a contract manager, and then she takes it to an assistant director, and he takes it to the director, and she takes it to the vice president, that is all still privileged. Now, conversations with your attorney are not privileged if the attorney is simply providing business advice or business opinion. So the attorney's got to be providing legal advice. That can include some business advice on the side, but the legal advice must be the main reason that you contacted the attorney or the attorney contacted you. So just copying your attorney on any random email will not necessarily make it privileged, even if you mark it as such. And you should mark things as privileged but follow your attorney's lead on that. So I mark my emails as privileged by either typing privileged or priv in the subject line and then writing attorney-client privileged in the first line of an email. Lack of markings don't mean that the email isn't privileged, but if your attorney advises you to use those privileged markings, please do. It just makes things easier in the event of a FOIA or other type of open record request. And be careful not to destroy attorney-client privilege by disclosing the privileged information to third parties. And this includes chatting with your family and friends outside of work. Keep in mind that even making a phone call in public or reading privileged memos on public transit, that could be enough to destroy privilege because you are letting that privileged advice leak into the public sphere. When I worked at a big firm, Morgan Lewis in DC, firm management would send out periodic reminders not to talk about projects in elevators or other public spaces, and not to review or draft privileged documents when riding the metro or sitting in a restaurant. So just be aware of privilege and ask your attorney if you're not sure of it. So we come now to the black hole of the legal office. Why is legal taking so long? And there are definitely times when it feels like your legal office is a black hole. Matters go in and just nothing comes out. And in the old days, some legal offices were slow just because they could afford to be. But now usually the office is slow because there's either an urgent matter that has intervened or the workload is simply overwhelming, or both. There have been times where I'll sit down with my morning cup of coffee and just immediately get pulled into an emergency, and that does the rest of my day is just gone, and I'm going to have to find some time to catch up with that. Or let's say there's a global pandemic and we need to effectively shut down all of our operations, take care of our people, take care of research animals if we have that, pivot all operations to an online format. In that case, I'm not going to be able to prioritize some no-cost copyright assignment with an academic journal because I'm focused on helping my client get through an emergency so that they can continue to operate. Even in normal circumstances, attorneys at government agencies are usually dealing with a really large workload. It's not uncommon to have 100, 150 active projects at a time. Now, that is nothing compared to the workload of a prosecutor or a public defender who might have a caseload of 2,000 projects at a time, but it's still a lot. And like everybody else, we've got to prioritize based on external deadlines and also the internal hierarchy. So if I've got to meet a federal deadline by Friday at 4, that gets prioritized. If the provost needs me, that takes precedence over, a contract manager. Another reason for the delay could be lack of resources. Many legal offices don't have support staff and they don't have access necessarily to electronic legal research tools like Westlaw. Or the legal office could be waiting on somebody else, including an external party. Or someone didn't involve the attorneys early enough. At the university, I often hear it's better to ask forgiveness than permission, and I will tell you that that is absolutely not accurate, especially with a government agency that's got to follow a whole myriad of laws and regulations, not to mention the U.S. Constitution. So it is better to make sure you do it right the first time. It is important to provide full and accurate information to your attorney. It's pretty unusual to have a client lie to my face. It happens once every 5 or 6 years. But many clients fail to provide full and accurate information just because it slips their mind or they don't think it's relevant. And then finally, a request can take time because it's legally complex. If there's not a statute or regulation on point, if a statute or a reg is brand new, they're not court decisions about it, then we've got to spend some time deciding on the best way forward. This has been a real issue when it comes to the pandemic. Early on, Congress passed statutory assistance, agencies issued regulations and guidance to help the public, but all of that comes with implementation and compliance hurdles. So practicing law in a rapidly changing statutory and regulatory environment with constantly changing facts on the ground has been a little bit difficult. And then you factor in the fact that your regular day-to-day legal work doesn't stop, so you can see how your agency's legal office might simply be backlogged. So a quick recap of best practices or tips for using your legal resources effectively. Develop that relationship with your legal office. Try to work with the same attorney on the same subject matter so that you just aren't developing the working relationship, but also shared institutional knowledge. Have your legal office reviewer create templates for you, contract templates, request for proposal templates, standard operating procedures, etc. Or work with them to develop checklists of potential problems and their solutions. So for example, my office has a document where we note all of the troublesome contract clauses that we have seen and potential workarounds for them. And I have posted that in our Canvas classroom just so you can kind of get an idea. Ask your attorney to come talk to your staff about various legal issues. Don't let things sit on your desk. Get the problems to your attorney right away. They are not going to improve with age. Try to request a reasonable deadline to help your attorney prioritize their workload, and then just make yourself available to speak with your attorney, and hopefully they will do the same for you. So that's it. Now you know the best way to work with your attorney, and you know the basics of administrative law, and as G.I. Joe says, knowing is half the battle. So since this is the last lecture of the semester, I just want to say thank you for being such a great class. I know that this has been a challenging semester because of the continuing fallout from the pandemic, and I really appreciate that you all stuck with it and just did your best in a difficult and dynamic situation. I hope you have enjoyed the course and that you find its concepts immediately useful in the real world. Like I said at the beginning of the semester, I want this class to have a useful, practical application for all of you who work in the public sector. Particularly now, in our fractured political environment, the government needs good people who believe in the government's mission, believe in the values set forth in the Constitution, know how government's supposed to work, and are committed to doing the best they can to serve the public. And I hope that this course empowers you to be one of those good people that we really need in government right now. Okay, due this week is our final discussion. That is course feedback and an Ask Me Anything. I would particularly like to know your thoughts about our textbook and A Fighting Chance. I am leaning towards swapping A Fighting Chance out for Michael Lewis's The Fifth Risk. I like the fact that A Fighting Chance shows you how an agency is built kind of from the ground up, but The Fifth Risk has been called a love letter to the federal bureaucracy and might be a little bit more broadly applicable. Your policy analysis summary, that is due no later than December 8th. Please remember to review the revised guidelines if you haven't already. And that brings us to the end. It was great to have you all in class. Stay safe, stay well, and I will see you on the discussion boards for one last time.